Sonst weiß ich nicht, wer noch kommt. So I don't know who else is going to attend, but since we are recording the meeting, I guess that doesn't matter too much. But it has stopped the proper screen share. Is that all right now? That is perfect. Very good. So what I would like to talk about is the EU AI Act, which recently entered into force, and looking at public administration as the course director of the public administration course of study, I would like to specifically see whether this enables public administration to use AI, or whether it is possibly even an undue burden. And since, well, I'm a German lawyer, I do this particularly from the German legal perspective. I would like to look at the aims of the AI Act, the concept of what is AI, AI use in public administration, what may be possible, threats, risks, and benefits of AI, and then I come to the main part, which is an overview of the AI Act. And my feeling is still that I'm scratching the surface, but there's still a lot more research to be done, which then brings me to the conclusions which I would like to offer. So if we look at public administration, its purposes are, of course, to serve the citizens, to provide good public services, to maintain public security, promote sustainable development, and generally to set a good framework for people and business to thrive. We will, in order to provide this, need modern and innovative administration with modern technology in public administration, and that will in the future, I am sure, include the use of artificial intelligence. But at the same time, at least the EU's position is that we need a legal framework in order to curb and control the risk, and because of the state power which may be exercised, it is particularly important that AI used by public administration will be trustworthy. And that's what the European Commission wants to achieve. The legal framework for the AI Act to use in the EU is the new AI Act regulation. Then we also have the General Data Protection Regulation, which deals with the data protection side of things in particular. And of course, AI can only work if it has data, which then to some extent may be counterbalanced by the Fundamental Rights Charter of the European Union, which I use as the model, the joint European Union model for fundamental rights protection. Similar rights, of course, exist in our German constitution, and they are binding on public administration. Yeah, the regulatory approach is a risk-based one. So the AI Act wants to regulate low risk, medium risk, and high risk AI, whilst prohibiting AI which is regarded as unacceptable in its risk. So sounds like a good framework to start from. And we have to then see what the European Union made of it. If we start with the definition of what is artificial intelligence, we have a legal definition in the AI Act, which has become very general. So it's a machine-based system that is designed to operate with varying levels of autonomy, and that may exhibit adaptiveness after deployment, and that for explicit or implicit objectives infers from the input it receives how to generate outputs such as predictions, content, or decisions. And decisions may even be administrative decisions that can influence physical or virtual environments. This follows the concept as it is used in international organizations such as the OECD. So it would be a definition with wider recognition even than the European Union, since the OECD also includes other Western industrialized countries. The Commission had actually planned to be more specific with mentioning specific types of AI where you actually need technological knowledge in order to understand this. So this is a listing of various AI types. But for instance, if you ask me to explain what Bayesian estimation is, I would have to say, sorry, I need to look this up. So that would be for people with a specific technological knowledge to understand. The Commission proposal was regarded as too broad. The Council wanted a clearer distinction from traditional software, so there was a debate between the EU institutions as to which definition to choose. By this more open definition as we have it now, we lose to some extent legal certainty. On the other hand, unwanted gaps in the law will be less likely, and it will be up in the end to the courts and to public administration to sort of break this down, make it more specific, and allow us to say spontaneously, well, this is AI and this is not. We have numerous more examples in the individual articles than to provide more legal certainty so that an undertaking, for instance, can tell, well, do I have to look at this or do I not have to look at this? What are the requirements? This is what practice will be interested in. The 4 criteria which unite all this AI would be elements of autonomy. It acts on data and inputs, which may be human or machine-based. It can infer how to achieve objectives by AI methods, machine learning, logic or knowledge-based approaches. And it produces system-generated outputs which interact with, well, the environment of the AI, say human beings, say applicants for public services, for instance, who would be affected by this. In public administration, potential or actually already existing uses would be predictive policing, like, well, where are crime hotspots, where should be more police present than otherwise might be, recidivism, search for victims or criminals, where one would then say, well, which, just for a parking offense or only for very serious crime. It may be used for public welfare, the award of benefits, for instance, to check whether a person applying for social benefits really fulfills the requirements. AI may be used in providing healthcare, with the robot replacing a nurse, for instance, in public healthcare. Then there's AI use in immigration, asylum, and border control. What will interest us in particular would be AI use in education. How far can we use AI in order to decide on access to courses of study, or how far can we use AI in order to see whether students cheat? Can we analyze their emotions during an exam, for instance? Then another one is personnel selection, or the sort of easier AI users would be giving general advice on application procedures, benefits available, for instance, where we don't need somebody to talk to people. They can work this out with the help of AI. This may make public administration more effective, more efficient, save cost. It may also be helpful to close retirement gaps in administrative staff. Looking at the development of our population, we have an aging population, and if we want to continue providing the same public services, we will need to do that with far fewer people. And therefore, AI may actually replace administrative staff. Another one is a potential promise of neutrality rather than human intuition. So biases which people may have may be cancelled out by the use of AI, which might be more objective. There are, of course, also dangers involved. So people say, oh, it's like nuclear weapons. People think of the Terminator movies where Arnold Schwarzenegger says, I'll be back. There may be the end of data protection because AI will need data to work on, end of privacy. And there's also the danger because AI can only be as good as the data it has been fed with, that it's just perpetuating bias and automating inequality rather than being more objective. Others say, well, this is exaggerated alarmism, overregulation. Europe is losing out because we are so old-fashioned and we are not open enough to innovative administration and innovation in general. And having this premature regulation may lead to just not having proper AI at all. It will be led by the US and by China, and we can then see what we want to apply from what they offer. The Commission is more optimistic, of course, saying that trustworthy AI may bring many benefits, better healthcare, transport, manufacturing, cheaper and more sustainable energy, and people will, on the AI Act, gain the confidence that they embrace the technologies. There are lots of optimistic quotes available too, which I think I'll skip. Remains to be said that the AI Act of the European Union is the first attempt to institute an AI legal framework. It's consumer protection law, actually. So a uniform consumer protection law regarding AI for the EU's internal market. And at the side of it, it's also data protection law. In terms of what it legally does, legal technicalities, it is a regulation which has direct application in each and every EU member state, meaning that it applies just like a member state statute, in spite of the sort of linguistic difficulties. Why do they call it an AI Act, which is to show that there's sort of democratic legitimacy behind this legislation. But in terms of effects, it includes individual rights and obligations for each person and for each undertaking operating in the EU internal market. And that, of course, includes public authorities because they are at least legal persons and they get their products from the EU internal market. They will be bound by the availability of what they can purchase on the EU internal market. And there are also rules in the regulation which specifically address public administration. The question which is of interest, particularly from the German perspective, is that there's no EU legislative competence to legislate on what public administration, how public administration is supposed to operate. The European Union lets the member states apply and execute its law. In Germany, this means that we have 17 sets of administrative authorities and administrative law governing this because we've got 16 federal states plus the federation on top. And this is autonomous. So the EU has no right to regulate how the member states organize their administration, nor does our federal state have the right to tell the Bundesländer, the German federal states, how to organize the federal state administrative organization. So Bremen in principle is autonomous as to how to organize Bremen administration. Unless there are specific inroads for EU aims, such as there are data protection or consumer protection, where the EU has a very pointed competence in one specific field, which may then also affect public administration. This is confirmed by the article defining the scope of application of this regulation. which is providers of AI systems, deployers of AI systems, and I would guess that public administration is mainly a deployer of an AI system. And then it's also importers, exporters, distributors, manufacturers, etc. And public administration is then addressed by the next article, that a deployer may also be an agency, a public authority agency or other body using an AI system. So it's crystal clear that this also applies to public administration. It's not just consumer protection or business law. Another one is that the member states' administration cannot just contract out of protecting fundamental rights in particular. If we come to an overview of the AI Act, we have 13 chapters with general provisions from which I've just quoted. And then the risk system, like this is unacceptable and therefore prohibited. This is high risk. This is medium risk with transparency obligations. And then there's a specific chapter on general purpose AI and a chapter on governance, because in order to apply this AI regulation, the member states will have to introduce and to set up an administrative structure to look at the, or to supervise the risk management and the risk control systems which undertakings have to put into place, and public administration too. This is a sort of picture on the risk classification. But if we now look specifically at what is prohibited, in a state governed by the rule of law and with respect for human rights, we would probably say subliminal behavior manipulation. Doesn't sound right. Exploitative behavior manipulation of vulnerable persons or groups. So it tempt, say, minors to buy dangerous goods, or to spend money they shouldn't spend and they haven't even got at their disposal, would seem a no-go anyway for public administration. Then we have social scoring. We have the risk assessment of persons, unless it's specific criminal involvement uses. We have a prohibition of facial recognition, but only if it is untargeted scraping of facial images. So it's not generally prohibited. We have the recognition of emotions in the workplace and in education institutions. Well, imagine you sitting on your desk and your emotions sitting there are monitored. Or a student is sitting an exam and we monitor their emotions during the exam. Or the biometric categorization on criteria which would form the basis of illegal discrimination. I think it's sort of easy to agree that we should probably not do these things. This would be first and foremost against the protection of human dignity, which specifically under the German definition is we must not make human beings mere objects of state activity. Human beings are supposed to decide for themselves. They cannot be moved around like pawns on a chessboard. We also have the right to physical and mental integrity. We have a right to private and family life, so privacy, and to data protection. They are all listed in the Fundamental Rights Charter of the European Union, made more specific in the General Data Protection Regulation. These rights would be easily violated by manipulating people's behavior or by social scoring based on a mere AI risk assessment. On the other hand, this may also be a problem for beneficial users of AI, like augmented reality systems, which may be used and are used indeed as a means of crowd control, say to prevent traffic jams, to make specific nightlife areas less aggressive. So what you can do is you can have specifically high-pitched noises which only young people can hear with their young people's hearing capacities. Older people cannot hear that. If you want young people to not be in a specific shop, or you can have sort of peaceful noises in order to make people feel more peaceful, less aggressive. It's a subconscious manipulation. Is that harm in itself, or can we say, well, it's used for the better, people are less aggressive, so let's continue using it? Still something to discuss. Then we have the right to freedom of thought, conscience, and religion, which social scoring might call into question if we try to interfere with people's freedom of conscience or thought or religion. Do we then give sort of religious social benefits or social scores on the basis of a behavior according to the religion, or do we deduct points if people circumvent rules of religion? Mark not legal rules, but rules which come from a specific religion people may or may not want to adhere to. So very difficult. And then we have the issue of biometric categorization, employing criteria which are not to be used as justifiable reasons of discrimination, such as genetic disposition and the like. This is also prohibited under Articles 21 and 23 of the Fundamental Rights Charter. So far for the unacceptable risk AI. The next category would be high-risk AI, which may pose a risk to health, safety, and may impair fundamental rights as just described. And there the AI Act puts forward strict requirements which are to apply before this may be used. Applying to systems that are either a product in themselves or a safety component of a product. And in the public administration context, if we go down the list in Article 6, we find quite a number of them which may be relevant. So machinery which is used by public entities, lifts and safety components for lists in public buildings, radio equipment where radio stations are public, as some of them are in Germany, personal protective equipment regarding police and rescue operations, and then critical infrastructure, appliances burning gases, fuels, medical devices in public hospitals, if we have robot-assisted surgery, diagnostic medical devices in public hospitals, civil aviation security, or rail systems where we want AI to be safe and trustworthy to operate the trains, otherwise we would just not want to use them. And there we would also have to look at biometrics, at emotion recognition, and the safety components of critical infrastructure as relevant parts of AI use in public administration. For us, education and vocational training will be particularly interesting, say, to determine access or admission of students, to assign natural persons to educational and vocational training institutions, evaluating learning outcomes, assessing the appropriate level of education. If you do a language course, for instance, you usually do a test to tell which level you should start at, or monitoring and detecting prohibited behavior of students. In the employment sphere, I think it's also easy to imagine how AI may be used there to manage workers, to see are their emotions like positive towards what they're doing. Recruitment of selection of people to become civil servants, for instance, that would be possible uses. And then we have the essential public services. I think I won't go into further detail there. To some extent, one might say that the area of migration is used as a bit as a guinea pig for AI. And again, we can use AI to apply to assess applications for, say, refugee status. Do people actually meet the criteria? This is what, as I'm told, is already happening. if the risk, even though an AI is in the high risk category, there's an exception if the risk is not significant. And then there's a counter exception again to say, well, where the AI system performs profiling of natural persons, it's always more than de minimis. So in that case, the high risk requirements apply. So it's not even easy to just say, well, this is within the high risk category. It may, because of the de minimis exception, be outside of the category, but if it's profiling, it is always within the high risk category. The measures to be taken in order to control the risk is first a conformity assessment prior to use, where in the end AI systems get the famous CE label, like this is a safe product in the European Union. After the conformity assessment, after a registration with a public administration, we still need to set up and a declaration of the conformity, and then the system may be placed on the market. This is followed by further duties of surveillance and development, and a duty to make sure that there's non-discrimination by design, that these systems must not discriminate on any prohibited criteria in the way they are set up from the first place. If there are changes, one has to start that again. Quality risk management systems are then to be put into place during the use of the AI, during the life cycle, to ensure continuous compliance and to demonstrate that the AI still meets the mandatory requirements for trustworthy AI in terms of data quality, non-biased data, for instance. There needs to be documentation and record keeping, so it's bureaucratic. Transparency. Information must be provided to users. So like with a cookie policy, you always have to agree or disagree. There always needs to be human oversight, and the whole must provide a certain robustness, in particular in terms of cybersecurity. If one looks at this in more detail, and details are still partly to be defined, I would like to ask, well, is this actually feasible for small and medium enterprises or for public administration? Documentation, record keeping, provision of information, that is a lot of bureaucracy attached to it. The management system would be based on risk identification, intended purpose evaluation. Is that risky? Then one has to look at other risks which are not intended but possible as an AI use. And then the adoption of measures. A, measures need to be adopted to keep it safe, and B, this must also be documented. Onerous. So it's quite far-reaching. It may be a competitive disadvantage for AI use in the European Union, both in the business and in the administrative area. It's supposed to be limited to risks which may be reasonably mitigated or eliminated through the development and design of high-risk AI, which makes me ask, well, what about the risks which cannot be mitigated? I still see a lot of lack of legal certainty here, and there will be a lot of further debate as to how to interpret the AI Act regulation regarding high-risk AI, I'm sure. Authorities and procedures I've already mentioned. And I would like to have a brief look at limited risk AI, which has to reveal itself, like in the Harry Potter films, like reveal yourself looking at a magical object. So there needs to be transparency. If there's a chatbot, like your friend Emma talking to you and always having an open ear, this chatbot needs to explain to the person you are not talking to a human being, you are talking to an AI system. Recognition systems, biometric categorization systems may be in this category. They have to reveal themselves in order to allow people to decide whether they want to continue using that. For public administration, this raises the question, if we allow people to make an informed decision, we will still need to keep administrative structures for those people who cannot or do not want to use AI in order to, say, claim public services. But, well, the duty for disclosure is certainly something to allow people to find AI more trustworthy in part of the on the part of the limited AI. With the high-risk AI, this is not deemed to be sufficient to protect people adequately. And then we have minimal risk AI like video games, spam filters, which we all use already, I guess, which are permitted without restrictions. Yeah, that's sort of by and large what there is. And the question remains, is this too restrictive for innovation, or is it too lenient regarding fundamental rights? Do we have to be more sensitive? Many AI users for public administration seem in the high-risk category. One might say rightly so, because of the enforcement powers of the state. Do we, in public administration, look particularly at little trustworthy AI? I don't think we can do that because it would be against human rights, which public administration is directly bound to. I can see that the conformity assessment procedures, the risk management procedures which need to be put into place may make AI a lot more trustworthy, and it remains to be hoped that it's going to work out. And another question remains as to member state sovereignty. Do we leave the member states free to use their public administration? Should public administration have more rights, fewer rights? These are all questions which still need to be discussed and decided. So the AI Act, in my view, is just a first step. And I think I'll leave it at this because I think I've spoken for at least half an hour. Is that right?
Yes, that's right.
Yeah, thank you very much.